This is Mike Franklin, the property tax guy, and today we're going to assess the assessor. In this particular case, it'll be Patrick Duffy, the sole assessor for the town of Manlius, Onondaga County, New York. And I've had a number of cases with Pat Duffy over the past several years, and so we're going to review all of that. It started three years ago with a commercial case that had previously been in state Supreme Court, and the petitioner had won the case, and the town had to reimburse them for several years' worth of taxes. The case took several years in Supreme Court to get straightened out, and as soon as it was eligible for the property to be increased legally, of course, the assessor, increased it again. It was a relatively small commercial property, and so he just raised the assessment again. So the petitioner got me involved to take a look at it, and we went before the Board of Assessment Review. I had issued a Freedom of Information Act request from the town, and I didn't get all the data that I had requested. We get before the Board of Assessment Review, and I reviewed with the Board of Assessment Review that I didn't receive the data from the assessor that pertained to the legal case. And Pat Duffy says, "Oh, I didn't know that you were looking for that." And I indicated that the requested the entire file that the assessor had on the property. And, it's pretty clear that he purposely evaded FOIL. So we proceeded on with the case. There's 3 members of the Board of Assessment Review, and it was pretty apparent that none of them had any interest in anything that it is that I was saying. And so with a commercial case, you can review it with the assessor, which obviously went nowhere. And then you can appeal to the Board of Assessment Review, which is a board of townspeople. And then your only other choice after that is to go to state Supreme Court. So I get in front of the Board of Assessment Review, and I was sitting in the room waiting my turn, and so you could listen to other people who were going before the board. And I heard this one conversation, and the chairman of the Board of Assessment Review, again for the town of Manlius, was this older woman, and part of the conversation went. She says the petitioner was a representative for a commercial property, and it was pretty apparent she's pretty sophisticated and knew what she was doing. And she got talking about LoopNet. And the chairman of the Board of Assessment Review says, "Where's Loop Street?" she says, So it was obvious she wasn't listening to what the person was saying, and also she didn't know what LoopNet was. And if you're doing commercial valuations and you don't know what LoopNet is, it's a bit of a problem, because LoopNet is essentially the multiple listing service for commercial properties for the entire country. So it was pretty clear that that woman was not qualified. My guess is that she was a longtime local realtor of residential properties, knew nothing about commercial properties. And, it looked like, anyway, she's no longer on the Board of Assessment Review, and nor should she be. But anyway, the other 2 members weren't too great either, because they denied this case, and they're forcing it to go to Supreme Court again. And we'd already won the case in Supreme Court, so they want to do it again and waste more time and waste more money, attorney's fees, all that kind of stuff. So anyway, well, it turned out the property owner didn't want to take it to Supreme Court because they kind of wore him out. The last case took 3 years, and the lawyer's fees and all this kind of stuff. And it was just too much aggravation, and so he gave up. So that was my first interaction: evasion of FOIL, and just plain incompetence of the Board of Assessment Review, and evil behavior by the assessor. So that got my attention that this assessor was abusive. So I solicited a bunch of people the following year, and I ended up having 6 cases before this assessor. And again, I foiled the data on these properties, and again he evaded my FOIL request and refused to give me what it is that I asked for. We had one case was a basically it was an apartment complex, and the property had recently sold, and the assessor, he pinned the purchase price as the assessment, and so there was other properties within the building that are identical, and they were all significantly less than this one because they hadn't sold recently. And you're not supposed to pin the purchase price as assessment, but that's what he did. And anyway, so we won that case. We had another case where there was a recent sale, and again the assessor pinned the purchase price. It's selective assessment. It's violation of welcome stranger. We won that case as well. And let's see, we had another one up on Henneberry Road. There hadn't been a sale of that property. That was just a comparable analysis case. We made our argument and we won that case as well. We had another case. It was a pretty high-end house. It hadn't been updated in 30 years. And so, we won that case as well. We had a piece of land that doesn't qualify for SCAR. We went for the Board of Assessment Review. Actually, the property owner did that himself and got nowhere. And so we had to go to state Supreme Court, and we won there. And because it was just, clear, obvious, selective assessment, and it could not have been more obvious. The assessor refused to negotiate, so we had to go to Supreme Court. We had to spend money on an attorney, and we had to file. And as soon as it got filed, then it was no longer the assessor's hands. It was now in the town attorney's hands, and it was now in the town supervisor's hands. And they settled the case, and that one was done. The one case that I didn't get a reduction on was what I thought was the most obvious case. But I can't blame the hearing officer because it was a large house. It had big curb appeal, and I can appreciate how, and it's a very well-known house. It's very close to the road, and so everybody knows it, and it just looks like a gigantic house. And that's because it is a gigantic house. But the problem is it was built in the 1950s, and it's very expensive to heat. It's very expensive to maintain, and those things impact the fair market value. And I might also add that the assessor had assessed the land, the parcel, at about 2.5 times higher than all the neighboring parcels, which are basically identical. And the assessor says, well, the land doesn't matter. It's the total assessment that matters. Well, if that's true, why does the state track land? And so, if it meets his agenda, then, it doesn't matter. But if it doesn't, then it does. It's just ridiculous. But to me, the fact that his land assessment was 2.5 times everybody else's was just an indication of what a lack of valuation had been done on it. There's just, the whole assessment was haphazard. And so the land assessment was haphazard. So more than likely the property assessment was haphazard. He basically didn't do an evaluation. And I can appreciate that because he has about 15,000 properties to value. But when you apply mass assessment techniques and there's an outlier that the property owner brings to your attention, you need to look at it. But this guy just digs his heels in. He thinks everything's a competition, and he refuses to cooperate and make a reasonable adjustment. So things will end up in state Supreme Court, costing the taxpayers money, costing the petitioner money. It's just, he's ridiculous. And also, he and I had a conversation because in the hearings, things got contentious. So he wanted to have a conversation with me outside the hearing. And I told him, Pat, I foiled the data. You didn't give me the data. It's in violation of New York state law. He says, Mike, I'm not interested in giving you the gun to shoot me in the head with, he says. I mean, he admitted to evading FOIL. It's illegal, but he does it anyway. And but also in one case, he has a checklist of technicalities to get taxpayers petitions. dismissed. Like, for example, the one property up on Henneberry Road, he tried to get the case dismissed, claiming that the petition was filed 1 day late. And this was during COVID. So this taxpayer had been paying taxes on this property for nearly 40 years. You know, he's just a long-standing taxpayer. And he wants to dismiss his petition, claiming that he didn't get the petition filed in time by 1 day. And well, it turned out that that wasn't the case. You know, initially the hearing officer dismissed the case, and then we went back at the hearing officer and explained to him that it was postmarked in time. So they continued on with the hearing, and we prevailed. But it's just outrageous that he would do that to a taxpayer. And another taxpayer, a young guy in his late 20s or maybe early 30s, had bought a house, and apparently he sent the petition has to go to certified to the court clerk, to the county clerk, a certified version to the town clerk, a regular version to the school district secretary, one to the county treasurer, and one to the supervisor. So they put you through all these hoops, having to send copies all over the place. I've seen people spend more than $100 on copies and postage to file these petitions. It's just a bunch of busy work. You should be able to file online and everybody can get their data from the county website. But no, so anyway, this assessor had the case dismissed because apparently he sent the petition to the wrong person at the school district. And so they dismissed the guy's case. Had nothing to do with the merits of the case. It was just because he sent it to the wrong person. And I checked with these school districts. Every time I have an opportunity, I talk to the school district and ask them if they actually read these petitions. They do not. One woman at the school district told me she reads it because she just likes to see, how it impacts her taxes. It's just ridiculous. And I guarantee you the county treasurer doesn't read this stuff either. The only reason that they would read it is if it was an Amazon warehouse, or a shopping plaza or something like that, or it's the Carousel Mall, they might read that. But Pat Duffy, so the Board of Assessment Review, the one taxpayer with the big house I told you about, he went before the Board of Assessment Review. They gave him 5 minutes. Guy pays almost $30,000 in taxes. They gave him 5 minutes and they cut him off. And it's just ridiculous. They got 15,000 properties. The town of Manlius doesn't mind collecting the tax money, but they don't want to provide the service, to give people, proper, appeal options. It's ridiculous. So let me see here. The most evil part is his checklist to get cases dismissed. It's just outrageous. So, I'm going to give a grade to the Board of Assessment Review of the town of Manlius, and I'm going to give them an F because they are dismissive. And also, when they provide their decisions, they do a checkbox, and they it just says insufficient information, even when people provide volumes of information, and it's just plain wrong. Let's see, and I'm going to give Pat Duffy an F as well, and I'm going to give the town of Manlius, they get an F. This is Mike Franklin, the property tax guy. Thank you very much.